This hearing is in the matter of case CFI 060-2019 before the Judge Roger Giles. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Clyde and Co. Lead counsel is Mr. Richard Little, QC. The defendant is represented by Mr. Jigar Gandhi. Thank you.
Yes, your gentlemen, this is a pre-trial review in anticipation of the hearing on the 5th of December, but there has been a development in that the defendant is currently unrepresented. I'll just make sure that Mr. Liddell is aware of that.
Yes, sir, I am. Received a copy of your order yesterday, so I am aware that Baker McKenzie have come off the record.
Yes, thank you. All right. Well, Mr. Gandhi, that means that the question is, what's the defendant going to do?
I'm sorry, I missed you there. Can you please?
The immediate question is that now you no longer have Baker and McKenzie acting for you. You need to get someone else for the hearing on the 5th of December, and for work to be done before then. What are you going to do about it?
I'm just waiting for actually even I didn't have clear instruction from my management that how we would like to proceed on this. I'm just waiting for the final instruction from my management, and as soon as I receive it, I'll pass this on to the honorable court, as well as I'll keep informed Clyde and Co. Just that as you may be aware, in India, the festival season has just kicked off. This whole week it's like holidays here in India, so Diwali vacation. So I'm just waiting for my senior management to give me clear instruction, and as I said, as soon as I receive, I'll keep the court informed, as well as the Clyde and Co.
That's not terribly helpful because, as you know, some things have to be done immediately. In fact, at least one thing is overdue. That is, as I understand it, a report in reply from your expert. Do you know what the position is about that?
Yes, so yes, so the final expert report was just served on Clyde and Co. yesterday. So with the due date was yesterday. So the final expert report was served onto them.
Thank you very much. I saw Mr. Liddell raised his hand. You were going to let me know that also, Mr. Liddell, were you?
I was, sir.
Thank you very much, yes. All right. Well, then, however, some more things need to be done in the very near future. So it's really not very satisfactory to be waiting for you to be told that you can tell us and tell Mr. Liddell and Clyde and Co. What's happening.
I know. So basically, the operating team who was directly dealing with Baker McKenzie, who have just come off the record, and so just waiting for my top management to take the final call of appointing some other counsel on an immediate basis. So I think they've already started the dialogue. So as soon as I think we get to know, I'll be informing the court the soonest. Just bear with us. So because I think this was so unfortunate and it just come off the last minute. So even I was not aware of. So I'm just waiting for the final instruction, and as soon as I receive, I'll keep the court informed.
All right, Mr. Liddell, what do you suggest we should be doing?
So we should be progressing this to trial on the basis that the trial will continue to proceed on the 5th of December. The outstanding directions are set out in my notes. I don't know whether you have a copy of my note.
Yes, I do.
So would it be helpful for me to give you a page reference in the bundle, or I see you may have a hard copy?
I have a hard copy, thank you.
So it's internal page 5 of my note, which is paragraph 16. I don't know whether Mr. Gandhi has a copy of I think a copy of the bundle link was sent him. It's page A5 in the bundle.
Yeah, Mr. Richard, I just was the copy of that bundle was just sent to me. So I unfortunately, I'm very sorry I could not access to it and I could not read through it.
Well, it might be a good idea if you took notes then of what Mr. Liddell is going.
Absolutely, absolutely.
Yeah.
So paragraph 16 sets out the steps outstanding prior to trial. The first and second are the reply expert reports. Mr. Gandhi has confirmed that the reply report to Mr. Al-Zaruni, which is at 16.2, was served yesterday. We were, of course, ready to exchange ours yesterday, but given the circumstances and the need for an address for service, that hasn't been done, but I assume will be done today. So 16.3 then is a joint meeting of the experts scheduled for the 4th of November. One would expect that that meeting can still go ahead. The experts can meet and discuss without the need for a new firm of solicitors, and HME presumably will be able to give instructions to the expert to arrange a meeting with Orient's experts. And then there's a joint memorandum at 16.4, sir, which is due by the 11th of November. Again, that will be a matter for the experts to produce that rather than the parties or their lawyers. And then, so we've got the chronology due on the 4th of November. So you might recall that one of the matters that we asked you to extend was this date for the chronology, and we had proposed the 21st of November. There were two reasons for that. The first was to give the parties some further time to produce what will be an effective and helpful chronology, and in circumstances now, that extra time is probably all the more needed. And the second was to enable pagination of cross-references to be included in the chronology. And you'll see from 16.6 that trial bundles are due on the 14th of November. So what we would submit is that none of those dates should cause any issues for the defendant, subject to the date of the chronology being pushed back to the 21st of November. Trial bundles, of course, the greater amount of work in relation to that will be done by my instructing solicitors, Clyde & Co. Needless to say, a draft bundle index will be provided, so there is some need for the input from HME or its lawyers. So there's then a reading list and skeletons on the 25th and 29th. I appreciate, sir, that if the defendant does instruct new lawyers late in the day, there will be a lot of work for them to do, but we would resist any suggestion that this trial should be pushed back again. And by that I mean the trial was originally listed to be heard on the 14th of March of this year. So then the trial was pushed back to the 31st of October. You may recall that Adelshaw Goddards, who were on the record prior to Baker and McKenzie, they came off the record on the 6th of June. The trial was then pushed back, as I said, to the 31st of October, and then again to the 28th of November, and then finally to the 5th of December. And so the claimant is naturally keen for this matter to proceed. There have been issues of availability in the past of the lawyers. I am ready. My diary is clear for the trial. And so, sir, what we submit is that you should give any necessary directions to progress this to trial on the 5th of December, whether or not Mr. Gandhi is in a position now or in the next few days to confirm, what lawyers, if any, he's bringing on board. So there are a few other issues I have, including whether this matter will be virtual or in person, but perhaps maybe I should leave that till after, but I'm in your hands.
All right then. Well, Mr. Gandhi, it does seem that the meeting of the experts and the preparation of their joint memorandum is something which can continue with the defendant engaging directly with its expert. In other words, instructing the expert to participate in that meeting and to join in the joint memorandum. It seems to me that that's something which I can expect that you will be doing even while management is deciding or engaging with a new firm of solicitors. Do you accept that?
I do. Definitely. Just with your due permission, I'll be definitely speaking with an expert and just checking out his final position. And most likely, I expect that yes, it will go on like Mr. Richard said, on 4th of November, and further submission maybe on 11th of November.
I would expect that to be done, because then the crunch time for having some more lawyers on board is probably going to be in time to get the agreed bundle on the 14th of November, because that will need input from them to make sure that the documents that your side wants to have before the court are in the bundle. So that's going to be the time for you to work to make absolutely sure that you have your new lawyers in time for them to participate in that. And as Mr. Liddell said, there's going to be a lot of work for them. So you'll have to engage lawyers who have the time and the manpower and womanpower to do that. And I take it you accept that also.
I just request here to Mr. Richard as well as to your good self, sir, if we can get an extension. I know I heard Mr. Richard on that, so of course they are resisting on giving us any further extension. But I would sincerely request the Honorable Court as well as Mr. Richard if they can allow us an extension for preparation of this pre-trial bundles, as well as make further preparation, and also the hearing which is due on 5th of December.
I can assure you that the one thing that is not going to be moved or extended is the hearing on the 5th of December.
Right.
We would take that as gospel.
Okay.
So therefore, I think that we must stick with the existing timetable.
Right.
Therefore, you must, and I repeat, must make sure you get that lawyer. I don't know whether you need to do more to inform your management of the complete efficiency of this, but you'd better do so.
Right.
I agree with the proposal that Mr. Liddell has put forward. It seems sensible that the time for the agreed chronology can be it need not be the 4th of November. It would be much more efficient to defer that, and that can be made the 21st of November. That's going to be fairly incidental. When you have your lawyers on board, that can be taken care of in due course. So I think the important thing, Mr. Gandhi, is that the trial date is going to stay. You are just going to have to get your new lawyers on board for the crunch date of at least a little time before the 14th of November, and they're going to be lawyers who have the time and the resources to put a lot of work into this to get up to speed. Okay.
Right.
I don't, at the moment, I'm not inclined to make any change to these directions. You've got a list of them, or you'll find it in the papers that you've been sent, and you must just act accordingly and make sure your
Right.
new lawyers know of them.
Right.
Okay.
Right.
All right. Well, now, Mr. Liddell did want to raise some other matters which may be purely mechanical. Let's hear what he says about that, and we'll see what, if anything, needs to be done about them. Mr. Liddell.
So thank you. There are just 2 points. The first relates to the hearing itself. My instructing solicitors have been informed by the court that this will be a virtual hearing. And my understanding is that hearings or trials in the DIFC are still essentially being held virtually rather than in person. My solicitors, I think, have written to Baker McKenzie in relation to whether or not they would be agreeable to an in-person hearing if that were agreeable with the court. But obviously, in circumstances where they've now come off the record, the position is unclear. So there may be a provision that all hearings continue to be virtual full stop. So I just wonder whether or not you could tell us the position, whether it's your preference for this to be virtual, whether it's just a court's overarching provision that hearings continue to be virtual rather than in person.
When you say person, do you have in mind that I will be present with counsel in the same room in Dubai?
So that was what I was envisaging. I don't know, sir, where you are based, so forgive me.
That will not be happening. I'm in Australia. I think as of today, I might be allowed to leave the country. I have been locked in for the last 18 months or so, but I will not be travelling to Dubai in the immediate future. So it will all be virtual.
Thank you, sir. So the second point, which I can deal with very briefly, is that my instructing solicitors wrote several weeks ago to Baker McKenzie in relation to the reply factual witness statements of HME, requesting some further information and documentation. That hasn't been responded to. I know that Mr. Gandhi will have a lot on his plate now to get lawyers on board, but it is important that we understand the case that is being pursued, and documents that should be provided are provided. I just put a marker down on that just so that Mr. Gandhi is aware, because he may not be aware, but we will have to follow up with Mr. Gandhi after this hearing in relation to that, and hopefully we won't have to trouble the court in due course in relation to that request.
Yes, thank you. I'm not at all aware of what lies behind that, but it is sensible, Mr. Gandhi, that you make a note of that and make sure your new lawyers know of it. I think it would be important, you do need to have an address for service. I think you've been informed of that by Baker and McKenzie. Have you actually told the court of your new address for service? That is the defendant's address for service.
I didn't hear you, sir.
Have you told the court the defendant's new address for service, so that there is, as
Yes.
it were, an official address?
Yes.
Yeah.
I just informed. Yeah.
Can you tell me what it is, please?
It is my official ID, so which can be used for the purpose of solving the documents or addressing any other matter under this particular case.
That's your email address, is it?
My email address, yes.
Yes, thank you very much. All right.
Sir, sorry, I did have another point, which is practicalities for you and bundles. So would you like some or all bundles couriered to you, or core bundles? What would best be for you in relation to bundling?
There is a considerable advantage in having hard copy core bundle at least, in the way I work, Mr. Adele. I appreciate the reason for your request, and I thank you for it. So if that could be borne in mind when the bundles are prepared, at least preferably couried if that can be done, and the rest can be online available.
So one potential approach which you might find helpful, which I do, is to have the pleadings, witness statements and expert reports and policy all in hard copy, but with the exhibits and the chronological run of documents online electronically. Would that perhaps be a good compromise?
It depends. I would expect a core bundle to contain the exhibits which are the core documents. I would normally have, because I would normally print them off online, the pleadings and the witness statements myself. If hard copies of those can be provided, it will save me printing them off. But the core bundle of documents, I think, is important, and it would save a lot of time in the hearing.
Yeah, yes, sir. And in fact, that leads on to my second point, which is timings. So I'm sure you've done a lot of remote hearings, given you've been based in Australia for the last 2 years. But in my experience of doing hearings online and trials, they generally take longer than in-person hearings, not least because of technical issues or timings of referring to documents. So at the moment, you'll have seen from the indicative trial timetable in my notes that it's likely that this hearing will go the full 8 days. So would it be sensible to have the 9th day or the morning of the 9th day kept free as well, or in your diary and our diaries, in case of any spillover caused by the virtual hearing?
I'm not expecting the case will need extra time. It seems to me that that's ample time for this sort of case to be dealt with. I would expect it to be dealt with such efficiency that that will not be necessary.
Yes, sir.
All right. Well, Mr. Gandhi, you've got a lot of work to do in order to get others to do work. I think it should be. I don't know that you're aware of this, but if for some reason the defendant has difficulties in getting another lawyer, maybe of the same kind that caused the loss of Baker and McKenzie, under the court rules, a company can't appear at a hearing, it can't be represented at a hearing by someone other than a lawyer without the leave of the court. And the leave of the court is very infrequently given. We may not, and I hope we don't get to that situation here, but this kind of case is one which I think it would be quite remarkable if leave were given. So that may encourage you to take even greater efforts in getting your new lawyers for the defendant. All right.
Right. Sir, can you of course I do very well understand the consequences, but just to be very honest and very transparent with you, can you highlight the in terms of suppose, yes, you very rightly pointed out on of course I have a lot of work to do, including appointing a new lawyer and asking the new lawyer to come on the record and go through all these things and be prepared for this bundle preparation as well as this hearing scheduled on 5th of December. You just highlighted some of the consequences. Can you, if you don't mind, can you repeat, sir, again?
I don't follow your question. Sorry.
So, of course,
if you do not have new lawyers on board for the hearing, it is very likely that the defendant will not be able to be represented at the hearing, and so its side of the dispute will not be heard. It's as blunt as that. Do you follow?
Right.
Okay.
No, yeah. No, sorry. I just wanted to, make it very clear so that I can inform to my management, and that's the reason for this question, sir.
Yeah. All right. Well, I wanted you to well understand that there was considerable unlikelihood that if you don't have a lawyer, that anyone from the company would be allowed to represent the company. All right. Mr. Liddell, any comment, anything you want to add in that regard or not?
No, sir. Thank you.
All right. Okay. Well, I will hope that I don't hear any more until I see Mr. Liddell and whoever the new lawyers are on the 5th of December. So thank you both for your assistance today.
Thank you, sir.
Thank you, sir. My pleasure.